We're getting into our last conversation for the day now, and it's about redundancies in employment. We encourage you to call in, by the way, if you're facing redundancy, if you've faced redundancy and you didn't know what next, how to navigate, especially from a legal perspective, and what are your rights, what are you entitled to, what does the law say, what does your employer say? All those questions we're answering with unemployment and labor expert Ambrose Waigwa. He's in studio with us. Karibu sana, Ambrose.
Thank you very much. It's a pleasure.
It is a pleasure. Asante. We're just about to begin, but kabla tuanze conversation, Jano will share a quote with you. Tell us if it says anything to you, if it speaks to you, if it speaks to your industry, and then we can get into matters employment and redundancy.
Well said. So the quote is by Patrick Awua, who is a Ghanaian, and he said, "You cannot reform what you refuse to audit." You cannot reform what you refuse to audit. Does that speak to you on a personal level or even in the professional level? Which one speaks more?
It speaks to me both, in both ways, both at the professional level and at a personal level. In the professional level, to the extent that for you to make reforms, you have to have historical hindsight, you have to know where you went wrong, you have to have the data, and that would mean you would need to have carried some sort of audit. On a personal level, you will need to audit your life as well, to know whether you are living it well, or to find out what could be going wrong with certain things you are doing, and then be able to rectify that.
Oh, that's good. Please do self-audits, guys, by the way. Ni muhimu sana. Can't you just cruise through life non-audited? Yeah.
I agree.
Personal service announcement.
Led by Ambrose. Led by Ambrose. What's just redundancy?
Yes.
Let me start with the term redundancy. When I hear redundancy, I think big organizations, right? I think corporates. I think people who are employing people in the hundreds, in the thousands, people who have structures. But I know the definition of an employee is way beyond just the corporates, right? So what exactly is a redundancy under Kenyan law? And does it apply to everyone, including, for example, your domestic worker and everyone who is not in the formalist of employment? Yeah.
Thanks a lot. Now, redundancy applies to everybody, every employee, be it a domestic worker, to the gate person, to a person in a big office, basically across board. And I think most Kenyans, just like you put, would think of these terms as terms applying to big corporations and maybe the blue chip companies and those kind of organizations. But the Employment Act cuts across board, from your house to the boardroom. Now, the term redundancy is quite, the definition is quite a mouthful. But for the sake of this show, I will just call it a loss of employment through no fault of the employee. So it is an involuntary loss of employment through no fault of the employee. Yes.
Involuntary loss of employment through no fault. So a lot of employers will cite restructuring as a reason to lay off staff. So what truly qualifies as legal redundancy in Kenya?
So redundancy has two elements. Like we have stated, firstly, there is loss of employment. And secondly, it's through no fault of the employee. I dare add that it's also, it should not be contrived with the employee. So if you sit with your employer and decide that your job is abolished or there is no more need for you here at NTV, that would not be redundancy. It would be something else. It could be quitting. It could be mutual separation. It could be voluntary early retirement. It could be anything. For it to be a redundancy, it has to be something brought on you by your employer.
That you did not...
Yes, that you did not participate in. So for that to happen, usually it's because of a couple of reasons. Maybe your job is rendered superfluous, or due to financial reasons, which is a big factor here in Kenya. We are seeing many companies restructuring and doing retrenchments. All those are terms which would be synonymous with redundancy based on the organization. We have other times when technology takes over. So, for example, we've seen key firms using technology, and so rendering everybody's jobs superfluous. In the wake of AI, we don't know how that will go, but probably there will also be a couple of retrenchments and redundancies.
Is the term ever abused, do you think, the restructuring? Is it sometimes used when it shouldn't be used in order for an organization to maybe, I don't know, have its own agenda, which comes back to affect the employees? Do you think it's abused, or do you think, no, a lot of the times in Kenya, when a company says restructuring, it's valid? Or have you seen incidents where it's abused?
It's very much abused,
Oh.
and that's why the law has come to protect people during that process. The redundancy process ought to take certain steps or to follow certain steps, but we have seen very many instances when employers choose to ignore those steps, and cases end up in court. And there is also a lot of agitation even from the labor law movements and unions as regards certain decisions made by employers which affect employees and which show that there was some form of abuse.
Yes. Let me go into that process actually.
Yeah.
What is the redundancy process as the law requires it? And again, does it apply across the board for anyone who is an employee or an employer?
Yes. For the sake of our viewership, I would like to really insist on on the definition of who is an employee. And an employee is a person who is employed for wage, for service, under contract of service, for a wage. So that would mean that even in your personal capacity, anybody who you have employed to provide services and who you pay a wage at the end of a specified period, be it daily for casual laborers or monthly for persons who work for longer periods, is an employee. And so you find most people, especially the ones who we would say are not companies, will disregard these laws, not knowing that they apply to them as well. That is not helped, of course, by the fact that in Kenya, for you to look at these employment laws, you have to look through a variety of laws. So you'll find one thing is governed by very many laws, and that complicates the situation. So, for example, in employment, you find there is the Employment Act, the Labor Relations Act. You will find very many other subsidiary registrations and those kind of things. But for the sake of redundancy, it will cover everyone so long as you are abolishing that job.
Okay.
So in the case of,
before you even go into that, this is whether there's a contract or not, right?
Yes.
Whether there's a written contract, as long as you're employing the services of someone and you're paying them on a daily, weekly, monthly, that is an employee and you are an employer.
Yes.
Let's go on. I think it's good to get those out of the way. Yeah, because we think you have to have signed a piece of paper. Yeah.
No, in fact, for signing of a piece of paper, that is required when that employee is with you for 3 months or more. That is actually a requirement of the Act. Most people, especially in private realms, will not sign those contracts. They will leave it open, or sometimes they will. You will just do the normal arrangement, the one we do with our domestic house managers. But in real sense, they could even sue you also for failing to provide a written contract and for failing to do other statutory deductions. But that's a story for another day. As for redundancy, the moment you form an opinion, or the moment the situation becomes so bad for you and you can no longer hold this employee at your workplace, then you have to go through a process of redundancy. Otherwise, it will be termed as unfair termination, regardless of how good you will explain it, regardless of whether you will say, we ran this business and it got banned, and so there is no place for people to report to work.
Wow.
Regardless of whether you will say, we separated with my spouse, and so there is no need of keeping this domestic manager. Basically, regardless of the situation, you have to really
follow a process.
Follow that.
What is that process?
So this is the process. The process is, firstly, you have to do some consultation. with the affected employees. Now, this consultation has to be a proper consultation to try and find out whether there are other options outside of that situation. And also, it should not be for the sake of it. It should not be to tick a box. Like most people say.
Like public participation, how it's done.
Yes, like the way public participation is done. It should be for...
So it was just saying. Just
putting it out there. Okay. So not to tick a box. Meaningful consultation.
Yes, meaningful consultation with all the affected employees. Secondly, if the employee is unionized, you have to give notice to their union at least 30 days before the date when the redundancy is to kick off. If they are not unionized, you have to give them a notice in writing. So the notice cannot be by word of mouth, and neither can you say you send someone to inform them that there will be abolishment of job. So you have to do it in writing and state the reason for the redundancy. After which, now you will, or rather during that process, you will have selected the criteria for which to use while sending these employees for the retrenchment. And there are very many criteria. So you will have regard to age, to skill, and to...
Sorry, who are you notifying? Who are you notifying about the criteria you used?
No, for the criteria, you don't necessarily have to indicate it,
okay.
But you ought to follow a criteria so that it is seen to be fair.
Okay.
So, for example, if you talk about age, there is 2 ways to go about it. You can go last in, first out, or first in, first out. So if you choose to use last in, first out, and you have a group of 20 employees, and maybe you must make 5 people redundant, then the last 5 will go out. But you cannot cherry pick and say the last 2 and then the first two because it will be seen to be discriminatory.
Okay.
Once you've
that's
done...
interesting, because you could say that that's balance as well.
Yeah.
If there is a formula to it, that would be okay. What the law tries to prevent is when it is haphazard or when it is done in a very shambolic way, where you have no way of verifying that this is the criteria you used, and where you have no way of showing that this process was not discriminatory.
Right.
And it's also very important in light of the laws against discrimination, Article 27. We have seen people declare people redundant because they are pregnant, for example, which is in itself wrong.
Illegal.
Even morally, it's wrong. And they try to fit in, there's a way you can try to fit in people by looking for a criteria and basically just to ensure that you've targeted, let's say,
justify.
Exactly, you've targeted Janet, and you decide that from today, everybody who puts on glasses is redundant because maybe they can't see.
So that's the ways in which it's abused.
Yes.
And what cushioning exists for the employee. I know you've talked about the law.
Yes.
But I think a lot of the time people are then scared to go up against unfair redundancy.
Right.
So what laws exist? What's the low-hanging fruit of somebody who is just like, but I wear glasses. It's not...
It is what it is.
It is what it is. And I think this was an unfair redundancy. It didn't go through all the steps that you've mentioned.
Yes.
What do you then advise employees to do in that position?
Sorry, before you answer that, had you finished...
Oh, yeah, the steps.
The steps.
Yes, I finished the steps only up to... the point when you are doing redundancy. There are post-redundancy steps which are going to take place. For example, you will be paid for the notice period you are entitled to. So if your contract says you have a notice period of 3 months, you will be paid that. You will be paid any leave days that had accrued and not taken. You remember every month you have at least 1.75 days of leave. So if, let's say, you had been very hardworking and you had worked from January to October without taking leave, then all those days will be paid to you. You will be paid something called a severance pay, which is 15 days per each year worked. And if also your contract provides for other benefits, such as gratuities and those things, you will be paid those. So that will give you a bit of economic comfort while you are facing the redundancy.
Okay.
So that will come, we would call it a post-retrenchment process, but it is all related and stipulated in the law, as a process of, as a process to be followed during redundancy.
That's very helpful.
Yes. In the event that there was no contract, so there's nowhere that it says, I get this many leave days, I'm entitled to this, my severance pay is this, what happens?
So the leave days are prescribed by statute. So those ones accrue to you whether or not you have a contract. Just like overtime, for example. So if you have a 56-hour week, anything above that is overtime, whether or not you have a contract or not.
Right.
And just like the 30 days notice as well, there is a section called Section 40 of the Employment Act, which gives that as the basic minimum. So the 30 days notice is what will apply to you if your contract provides for either 30 days or you don't have a contract. There are people with contracts which provide for 3 months. So they will be paid 3 months notice pay. Yes.
Okay. So in lieu of a contract referred to the Employment Act, then what if the contract that you had signed is less than, in one way or the other, than the Employment Act? If the Employment Act stipulates that we get 28 days of leave, but yours said 20 or 15. If it said, there's a notice period of a month, but yours said 10 days, what supersedes the other? It's the Employment Act, right?
Yes, ordinarily it is the Employment Act. And what will happen in such situation, and not just in employment, but almost in everything, you cannot contract out of statute. So, for example, if murder is illegal, you cannot tell me that because you are done with life and you fear taking it yourself, I can take it for you.
Wow.
We cannot contract out of statute.
Okay.
So most people would, like I've said, and not necessarily out of ignorance, but maybe because they don't know these things apply to them, they would put clauses within the contract which are contrary to statute. But if eventually this person decides to enforce their rights, you will find yourself paying sort of like back fees for things you did not do. So, for example, if your employee has been taking 10 days per year and they have worked for the last 10 years, you will compensate for the balance of 11 days for each year if they decide to take action.
Yes, that is happening a lot, actually.
Yes.
So I think that there's two questions. One is, I'm glad you've contextualized what happens even post-redundancy. It might be similar to what you're saying. Okay, so then what action as an employee can I take if I feel like the procedure wasn't followed, I feel like the post-redundancy process wasn't followed? Is it through unions? You just say, no, I'm going to go directly to court. People fear, though. It's a power dynamic. If you're up against an organization,
there are a battalion of lawyers.
There's a battalion of lawyers. So it's for somebody listening and they're thinking, I don't know that due process was followed. Where would you advise them to start? And then I'll come to what you've just said about backdating, because I know somebody who has been affected by that. The person was advised that, yes, you were let go, but she owes you for 8 years back. But nothing was written, nothing was discussed. So now it's a tussle, it's a back and forth, because she's like, but we did not agree on anything. But as Ambrose has said, stipulated in the law. So those are two separate questions. So what do we advise somebody who feels like it was undue process, but they feel like they're also up against a mountain?
So what I advise most people who want to take up a matter against their employer is to ensure that their side of the document is very okay. So, for example, you could have a checklist and find out that really we were not consulted. Or in this meeting we were called and told to sign forms before the meeting, so we didn't know what we were called for. And then it was just announced and imposed on us that there is a redundancy. It was not necessarily
communicated.
It was not a consultation. It was us being told there is a redundancy and there is nothing we are going to do about it. Other than having the documentation right, you may want to consult an expert who will tell you what you are entitled to and what maybe look at what you've been given, do an audit basically, and find out if indeed you have a claim. so that you don't go in blindly and end up paying the legal costs for something which you could have avoided if you had consulted an advocate or an expert, a human resource practitioner, or somebody in the field in that regard. Once you find out that your rights have been violated, there is a specialized court. This court is a creature of the Constitution, and it is a court which only deals with employment and labor matters only. It's called the Employment and Labor Relations Court. So in this court, there is nothing labor that they have not had or seen or known since it's been there since 2010. And lately, the judiciary has really done a lot of work in ensuring that there are various stations of this court spread throughout the country. So it's, again, not a matter of fearing that you have to travel far for you to go and file suit. So it's a suit that can be filed in any forum.
Okay. Yes. Sorry, there's a question here I don't want to lose. Michael says, what happens if the employee decides to terminate and leave the job? What rights apply for them?
So when the employee decides to terminate, then it is no longer a redundancy, because you remember by the very definition of redundancy,
you have involuntary.
It's involuntary. So when there is some form of voluntariness or even some form of connivance with the employee, then it is no longer a redundancy. So redundancy has to be something which would come as a shock or a surprise. Even though in proper redundancies, it's usually not a shock, because you would have seen the redundancy coming. You would know, for example, company X is making some losses, and inevitably some people will have to go. I don't know whether it will be me or who it will be, but some people will have to go. So you'll have seen it a mile.
You'd see it coming.
You see it coming.
Okay.
Yeah.
I'm trying to think. Oh, this is actually a question before I even get to the one I had in mind. What of independent contractors? What realm, does independent contracting exist in the world of employment? Because it seems to be quasi-employment without the legal, oversight, but it is a contract. So it is legally binding. Explain what that is.
So independent contracting, or what is known as consultancy, is not employment per se, because that one is not a contract of service. It's a contract for service. But so that we don't confuse...
It's not a contract for service. Of service. It's a contract for service.
Yes.
Go on.
But so that we don't confuse ourselves with terms here. So maybe we can go to the longer definition or explanation, which is that for a consultant or for a person who is a contractor, this is a person who is... I don't want to use the word employed. This is a person who is brought to do something or to take up a specific a job or role, but is not considered an employee. So they give their services to the person who needs that service, and they come with their own tools. They organize their own timelines, their own KPIs, and they only deliver the results, as opposed to an employee who is given the tools by the employer, is basically guided by the employer on how to work. You are supposed to be here at 8 a.m. and we leave at 5, and we dress this way, and we do these are the terms. So that would be the difference between a contractor and an employee. So contractors are not employees, and so they are not affected by redundancies as provided for under the Employment Act.
Okay, so this one, there are actions by the employer that shows you are an employee, like being paid a salary every month by the employer. This action demonstrates that you're an employee despite not having a contract. So I think he's more or less making a statement, because the initial one he said is whether or not you have a contract, there's what we call implied contract in employment. I feel like sometimes this is being weaponized. Again, I use the example of the person I know who, and maybe I don't know whose fault it is, right? So you have a domestic manager, you've been with them for, say, 5 years. you've never signed anything, but obviously you've been paying this person every month. Then, for whatever reason, you find, I can no longer work with this person, I need to let them go. You essentially agree. Maybe you try part of the process of, hey, so it's not working. Thank you. Then they come back a few months later and say, oh, like they're represented, and the person says, now you owe for the last 5 years of either leave not taken or something. I feel like there's a weaponization that's happening. Maybe weaponization is a wrong word. There's a misunderstanding around what this no contract, yet it exists, especially with domestic workers. A lot of people don't sign contracts. And I know the Employment Act is important because it protects employees, but I think employers are now getting caught flat-footed. So how do you navigate that if you don't have a contract, and it could be this person will be left redundant because you're the one who will tell them, I no longer want your services, I'm not happy with your work. Then they come back and they say, cool, then you owe me for the last 5 years of, I don't know, I was an employee. The benefits, some of them even say, you owe me housing levy, you owe me for NSSF, but there was no contract.
Right. That's an interesting one. And I'll begin with, I'll just, on Janu's question, that's termination, not redundancy, right?
Yeah. In fact, I wanted to mention that.
I'm trying to think through.
When you say not happy with your work.
See, for them, they are made redundant.
No.
Right.
It's not every termination is redundancy.
Every redundancy is a termination, but not every termination is a redundancy.
And now to explain that, for when you say I'm not happy with your work, then you terminate them maybe for performance or for other things, which again will follow a different process.
Right.
For redundancy, it's very specific. The reason why we said at no fault of the employee is because for things which would be considered fault of the employee. So, for example, they could have done something which have made you not happy with their work, or they could have misconducted themselves. That would follow a different process of termination. But when it is purely no fault of the employee, and at the same time for factors beyond the employer's ability, then that becomes a redundancy.
Like maybe they lost their job and therefore they can no longer support.
Yes. But also you have made a very important point that sometimes you will separate with someone through whatever means, and they will come back later to haunt you. And that is true, and that happens for a reason. And the reason it happens is because, like I've told you, most people are not keen to check and to tick these boxes to find out if they are complying with the law. One of the most non-complied laws being the minimum wage order.
That's true.
Of course,
just give like our viewers and listeners what is our minimum wage as it stands right now? So
there is a subsidiary legislation which is usually issued every year by the cabinet secretary in charge of labor, which stipulates what is the minimum wage. And not only that, for artisanal people and for people in the informal employment, it states what they should earn. Be it drivers, juakali, technicians, domestic workers, persons who watch over our belongings and that kind of thing. And currently it's about 12,000 and a figure, and that's the minimum wage. I don't want to, but
let me do this.
Yes.
So, and we've had this conversation in like different forms before. That is our minimum wage, and it increases gradually every year. Of course, it's to protect employees and to make sure that people are paid a living wage. Right. And in an ideal world, it would even be higher. Then we factor in the realities of the country we live in, which is people require care for their homes, they require child care, they require this, they require that because they need to go out and work, but they may be earning, say, 20,000. So then we've set a wage at a minimum wage at 12. Unaona shida hapo. How do we marry? How does the law marry these realities? Does it just is it expressly if you can't afford 12,000, then you don't don't employ anyone? Or is there some...
It's a good question.
Yeah, that's a very good question. And I think that's a challenge. People who do public interest litigation should take up and say there was no public participation while doing that minimum wage. Because it's true, for some people who, or rather for most people, you cannot afford to pay that while yourself are only earning so much. Maybe it's a conversation which can be taken up by people who are keen to do public interest litigation and just go and maybe quote it and say that they should conduct better public participation so that they are able to find out what is the average Kenyan able to afford while employing the services of another person.
Right. And what can we factor into this? Because a lot of times you may not be paying that, but if housing, food is provided, then that has to be some sort of offset. I don't know. I'm just thinking.
It's fair. It's very fair. It's math that needs to be. It would be good to know the answer. But again, if the law is the law, then how are we just trying to make it fair on both sides?
On both sides, So now there are certain basic minimums which the law provides for. So, for example, it provides that you must pay housing allowance, which is about 15% of the basic salary. However, you don't have to pay this if you are providing housing. So
but
that
every other employee should get a housing allowance.
A housing allowance.
Okay.
And that's also the danger with not having a written contract. Because if later you are sued, you will not be saying that this was a consolidated salary. Because you'll be told where is the contract? Where is the contract? And then you'll find yourself in hot soup because you'll pay again that money as arrears. You'll pay 15% for every month for every year worked. And I know in one matter against a security company, the judge said that that employee should be paid 26 years of that money. And they ended up being millionaires in a night.
Wow.
But now I was telling you about the basic minimums in a contract. So the law also says you should provide water at your place of work. The law then says you should provide a salary. It even says where you should pay that salary. So, for example, you cannot pay salary at a place where alcohol is sold.
Sorry, you cannot pay a salary?
At a place where alcohol is sold.
So you can't pay someone in a bar?
Exactly. I can't tell you, let's meet at Bar X.
Okay.
And then I'll give you your check
as we drink.
As we drink.
Okay.
I feel like asking why, but I feel like maybe I'm the only one who doesn't know why.
I think there has to be something must have happened that informed this decision.
Okay.
It could be that you get paid and the counter is right there, and then next thing you don't have any money.
It could be that our lawmakers are creative and they thought
that should be part of the law. Okay.
The law then says you need to have at least 21 days of leave for every year. And you see, these are the basic minimums provided for in the law, even for a domestic manager. Maybe at the time you are separating, especially if it is for redundancy, you can enter into some form of something written, and maybe that could ameliorate or prevent you from getting into trouble later.
Right. To Semetu, we've cleared our debts with each other. We don't owe each other anything. Going forward, something of the sort.
Yes, going forward.
Okay.
And this is very voluntary. Nobody has been told to sign this. So it's called a discharge form. And that would work very well for you if things become bad later on. For other situations where you want to cover yourself, you may decide, you had asked what alternatives would you have. You may decide to do other things other than a redundancy. So for example, you could decide, let's do a mutual separation. A mutual separation is where you sit on a table, you agree mutually. Okay, you take this, let me take this, and this will be your last day. Then I will pay you this amount. You're entitled to this, you're entitled to this. And it becomes a very mutual process. And you shake hands and everybody goes. Or even if you don't shake hands, at least for the sake of
transparency,
it looks mutual. If it's persons who are above the age of 45, you can enter into a voluntary early retirement. It's the same thing. It's sort of like a mutual separation agreement, only that in this case, you are invoking retirement for this person to be able to enjoy retirement benefits. If they so wish, if they want to cash in at this time, they can cash it in.
Yeah, these are really good options to hear out loud. I was going to say it's consciously uncoupling, but I guess that's for
the other realm.
From the other realm. But,
exactly.
But, sorry, you were continuing because I wanted to read feedback from Bakari Sagna.
Yes.
In the context of protracted labor disputes, particularly involving county medical staff facing persistent salary delays or violations of their CBA, what would you recommend? That's not redundancy again?
That's not redundancy.
Yeah,
and
also,
redundancy. But maybe I can assist Bakari. So, like I said, one of the problems we may have, it could be a problem, it could be a challenge, I don't know what it is, but it's having so many laws regarding a particular subject. So, for example, right now, if, say, you wanted to look at this issue of employment, you may be forced to look at very many documents, including, like I said, the Employment Act, the Labor Relations Act. We have very many. So in the instance of county employees, they are not strictly governed by Employment Act. Strictly, I'm using that word. Reason being, they are governed by Public Service Act, and other acts within other legislations within the counties. So, for example, in the case of county employees, their first port of call is usually the County Public Service Board, and this is across board, across all counties. Then their second point of call, if they are not satisfied with what they have discussed with the County Public Service Board, is usually the Public Service Commission. So, you see, for them, the process is a bit different and a bit longer than it would be for a normal employee. So that will be what I would advise the listener, that maybe they can take up the issue with the County Public Service Board, which is available in every county. The first things the governors do when they come to power is to appoint people to the County Public Service Board, and their decisions can be appealed to the Public Service Commission, which is here in Nairobi. And if people are unsatisfied with the decisions of the Public Service Commission, then they can apply to now the court.
Okay. Yes. Just before we continue, there's so many questions coming in. We'll try and get through as many of them as possible. You can also call in. We have a few minutes left on 0719038858. But statutory deductions, is it an illegality for an employer to not remit statutory deductions? And what are the fixes in the event that it does happen? Even for those who don't consider themselves employers, because I think that's one thing we need to shift. The idea that thinking employers are only big corporates, yet we all have, a lot of us will have employees in the home.
Yes, it's illegal for employers not to remit the statutory deductions and to deduct them at source, because for all of these statutory deductions, they are deducted at source, be it payee, housing levy, SHIF, SHA, and NSSF. Now, what happens is when you do not deduct, you are liable for a fine under the various acts. They each provides for what you are liable for. But on the side of protecting the employee, there are also some safeguards. So, for example, if you don't remit NSSF, one day if that employee sues you, and one day could be any time from when the employment is terminated to the next 3 years. That's the limitation period. You will be told to pay 15 days for each year worked. That will be something they call service charge, which is payable to employees whose NSSF was not remitted, or pension, because some people will choose to go to a pension scheme, a different or in a different
a private pension scheme.
A private pension scheme, yes. So that will be what you will be told to pay. So eventually, it will catch up with you if you do not remit these payments. Yes.
a situation, this is Dennis Opondo asking, what about a situation where a corporate subcontracts an agency, for example, and they manage them on behalf of the corporate? Are they entitled to paid leave days? Okay. I don't know if I've understood the question.
Yeah. I think I've understood.
You've understood, okay.
Yes, yes. So again, in the employment realm, and employment is so vast, and some people have become creative over time. And one creative way of dealing with employment is where you decide, as a Nation Media Group, we are not going to have contracts directly with
employees.
With Janet so what we are, exactly. So what we are going to do is we are going to subcontract a recruitment agency which will employ people, but then or employ on their own behalf, but then now bring them over or subcontract them to us, but they are not our employees.
Hey, very, very clever. We've become suddenly very clever.
Yes. Suddenly we've become very clever. But now again, what happens in all these instances, including in the instance of private contractors, like you had asked before, if trouble comes and somebody decides to sue, that's when, before much goes on, you have again to go back to the drawing board and find out who was the actual employer of this person. Yeah.
So in this case, is this agency that's been recruited?
So
or is it the person subcontracting the agency?
In certain instances, the courts have said, due to the level of control and given the nature of the work, this person could not have been subcontracted. This was your employee, given the nature of the work. But in other instances, for example, in one case involving a hospital, the court said, no, this is not an employee of this hospital. They were merely subcontracted
by this agency.
Yes. So the agency now becomes the
liable party.
I feel like that makes sense. We literally have less than a minute. I wanted to find out about people who are not under traditional labor laws, like gig economy, NGO, because they still face redundancy, I guess. If it's an NGO, for example, and there's layoffs, so there's redundancy. Do they still have the same rights? Does the employee have the same rights?
Yes.
And still deserves the same due process? Yes,
they have the same rights. They deserve the same due process. And also, it won't matter that you will say, this is once in, let's say, once in a while job.
Yeah.
It won't matter. So long as you've figured out you cannot maybe sustain the wage bill, or you cannot continue because maybe AI has taken over, or for any other factors beyond the employee and also somehow beyond the employer, then you have to go through a redundancy process.
Okay.
Yes.
We're closing.
Yeah.
Oh, you had one more question.
No, maybe mine was closing, was just like, how do you talk to Kenyans about surviving
a redundancy
economy?
Right.
Just a parting shot, but maybe you had one before the parting shot.
No, it was just that, because I'm looking at the figures again. Our unemployment at 7.23%. 60% of Kenyan businesses intended to halt new hiring. Of course, I don't know how many of those will actually be firing. But yes, how do we survive redundancies?
Yeah, there are certain ways to survive redundancy. One way, other than what I would call the cliche ways, which would be, you need to make yourself
indispensable.
Indispensable and those kind of
and
things.
And it's like, no one really is indispensable, but true.
But one way is obtaining insurance for your job. So there are many insurance service providers which will who will insure your job, even banks. For example, if you take a loan, the first thing they ensure you do is sign off an insurance. The second thing will be, of course, to save for a bad day and to plan for it. And the third thing will be to spend wisely. The money will be paid after redundancy.
Okay.
Yes.
Well, that's really good advice. We might have to leave it there. I very quickly want to say that we have Your World coming next, Breaking the Flow of Silence, the monthly mental load. We have Winnie Lubembe, I believe, will be hosting that. And there's a new app as well that the Nation app, right? The Nation Media app.
Yes.
What are some of there's some fantastic features. It's a single login across all platforms. Personalized content feed, so you're able to get exactly what it is that you want to consume in terms of content. And yeah, it's available on The Google Store.
That's
Google
right.
App Store. What else are you looking forward to for the app, Mariam?
Quite a few things. I think the idea of just finding everything all under one is for me what makes me happy. Not having to switch between app to app, close this window, open this window. I already have 100 tabs open.
Yeah.
So if we can do one less, that's fantastic. But as you're seeing there, some of what will be offered there, you can watch NTV. You can also listen to Nation FM. Like right now, we're going into the Vibe Shift on Nation FM with Claudia Naisabwa and Brian Aseli. So you can go listen in. You can, of course, also read your dailies. Apart kusema Taifa Leo na Business Daily, na Daily Nation, you don't need a physical copy. And over the next few days, we'll, of course, let you know more about the Nation app. But the idea is an umbrella for everything that NMG offers.
Yes.
Makes it easy for you to, of course, make sure that you're caught up on everything that you need.
Yes.
Your world is coming up, and of course on Nation FM we've got Vibe Shift with Claudia and Brian. Thank you so much, Ambrose. Asante,
You're
asante
welcome.
sana. It's been a wonderful morning. Bye.
Bye. See you.